Hello, everybody, and welcome to what is actually the last webinar with David in this landlord lockdown training series. We've just got one more webinar in the series, and that's next week with David Cox. So in this webinar, David is going to be talking about data protection and the GDPR. David, as you will know, is a solicitor and partner of JMW Solicitors. Welcome, David.
Hi, yes, David Cox and I are different Davids altogether. So this is my last session with you, and it's a different David next time out.
Yes, there's lots of Davids. I mean, with our conference, I think we've got 3 Davids, so it's sometimes a bit difficult to work out which one's which one. But this is David Smith, solicitor, JMW solicitor. So take it away, David. Tell us all about data protection, the GDPR, and what we ought to watch out for.
Right, so I'm going to just talk a little bit about some key points. I'm not going to talk about the whole GDPR. I'm sort of assuming a little bit you know a bit about it. If you don't feel you know very much about it, I highly recommend the ICO's website. It's a really good GDPR resource. I would also, of course, have to highly recommend my own book called GDPR for Property Professionals, which I recall Tessa has done a review of. So you might want to read the review and decide whether that's for you as well. Although you could actually wait, because I'm about to do a second edition, which will probably be out by the end of the year. So you might hang on and see what I put into the new version of it, because I've got to update it now for the more complex post-Brexit GDPR situation, where we now have EU GDPR and UK GDPR and the subtle differences. Right, so hopefully everyone can hear me and can see the slides and all the rest of it, and we'll just charge on as if you can't. I'm sure Tess will throw up a standard message at some point saying what to do if you can't hear us, but logging out and logging back in is usually a good start. So let's talk about 10 traps for the unwary in relation to data protection. One, the first one, to be honest with you, is think it doesn't apply to you. The number of people I hear who say, oh, but surely, especially small private landlords, who say, oh, GDPR doesn't apply to me because I've only got one property, that's a mistake. Anyone who processes personal data is caught by the general data protection regulations. And obviously, as I've already indicated, the fact that we've left the EU has got nothing to do with it. We have still got the GDPR here. We now call it UK GDPR, but it is the same to all intents and purposes. The differences are much more of interest to me than they're likely to be to you. There is an exemption for private family processing. So if you're processing your personal data for private purposes, for example, there's nothing in the GDPR that prevents you maintaining a personal address book of your friends and family members, for example. There's nothing that prevents you running a small local bridge club or whatever, or poker school or something like that, and maintaining some records associated with that. So private family and personal processing is not caught by the GDPR. But, and this is the important point, that does not include private family businesses. So I get people who get confused about this and say, well, I'm running a property which I rent out for my family finances. That is not covered by that is covered by the GDPR. That's not exempt. So almost all landlords are processing some personal data in relation to tenants, not least, for example, their names and their rent records. And so you will need to deal with the GDPR. You will be captured by the GDPR. Agents are doing even more. I'm sure there's some agents signed in here as well. Agents are doing more than that, because they're presenting personal data not just of tenants, but also of landlords, and of course of prospective landlords and tenants as well. So marketing prospects. So they're processing quite a wide range of potential different data, all of which is likely to fall within the realm of personal data. Second error, not appreciating the scope. GDPR covers any personal data, which means anything that identifies a data subject in the very widest sense. So if you collect IP addresses, or you have someone's mobile phone number, or they log into your Wi-Fi and you record that information, even if you don't realize you record it, then all of those things are captured by the GDPR. So GDPR is not just about situations where I record people's names. It's about where I record any data that can be reasonably used to identify somebody. So, for example, it doesn't even have to be a name at all. If you identify a solicitor at JMW Solicitors who specialises in residential landlord and tenant law, you have identified me. If you're using that as in the context of a personal information or using it outside my professional capacity, then you are subject to the GDPR. The form of storage that you have is completely irrelevant. So the type of storage, the way you store the data is neither here or there. I mean, it doesn't matter whether it's paper records or electronic records. The form of storage, the GDPR is quite electronically focused, and people often talk about it in terms of computers, but it covers paper records too. And there's no difference. You can't escape the GDPR by only sticking it on paper. The only exemption to that is totally unsorted paper records. So, for example, if you have a notebook on which you note down various bits of information relating to your properties, but don't file that data, and it's completely unsorted, and it's not one notebook per property or one notebook per tenant, it's just a general to-do list on paper only, and it's completely unsorted, then that record would not fall within the realm of the GDPR. Okay, but the vast majority of any kind of filing of paper records or paper records that are structured or sorted in any way will fall within the realm of the GDPR. And electronic records are always structured by definition, so they will fall within the scope of the GDPR. So people underestimate the scope of what we're talking about here. It's not just about situations where I've got someone's name and address. It's any context in which I can identify a person. Security. I can't emphasize enough how much this is not taken seriously. Computer security is fundamental to the GDPR. I constantly run up against individuals who say, oh, no one's going to hack my computer, or agents who say, oh, we're too small a business, no one cares. The reality is the evidence is completely against that. I'm sure most of you have seen news stories about increasing numbers of scams and hacks that have been going on during lockdown. Everybody is subject to computer security risk, and turning around and saying, oh, I'm too small, I don't need to worry about spending money on computer security is plainly wrong and very, very dangerous. If you lose your laptop, and that's enough to have a data breach. If you lose your mobile phone, you will probably create a data breach. And if you haven't encrypted it or secured that data, you are potentially liable to a fine. There was a barrister who lost their laptop and was fined several £100,000 because it was unencrypted. Now, admittedly, she had a lot of records relating to child abuse cases that she was working on, but there can be a lot of sensitive material on a laptop, and you can be fined. If you have all of your tenants' records and all of their bank details and all of the tenancy agreements for the last 5 years on your laptop, and you lose it, and the ICO finds out about it, and it's unencrypted and has no password protection, or your password is hello, then you're asking for trouble. Things like encryption and secure passwords should be a norm for any person operating a computer in any reasoned business sense, and frankly, for anybody. It is perfectly free. If you've got a recent version of Windows, you can encrypt your laptop using Windows standard provision. Apple Macs are encryptable with password protection using BitLocker and other similar mechanisms. Mobile phones can be encrypted. They're all encryptable for free, built into the operating system. Equally, secure password standards should be normal to you. You should have a secure, that means unguessable password, i.e. not your daughter's name, or your wife's date of birth, or hello, something secure that is changed routinely and regularly. And of course, you shouldn't use the same password across lots and lots and lots of different systems. If you use your password on 5 different systems, then it's only as secure as the least secure of those systems. And there are entire websites in the dark web devoted to selling lists of passwords. In fact, there's quite a famous one. You can go and check if your data has been stolen and used, called "Have I Been Pawned?" And you can go and look this up and actually type in your email address, and it will tell you if your name and password have been put onto the dark web. And frequently you will find yourself in there. It's quite surprising how often you can find yourself in there. So you should be thinking about these things. You should definitely consider, for example, a secure password management system. Personally, I use LastPass, but there are lots of other ones available. You should be thinking about encryption of your devices. You should be thinking about a VPN system, particularly if you work in coffee shops. Obviously, nobody works in coffee shops at the moment. But in normal times, if you work in coffee shops and use unsecure Wi-Fi, you should be thinking about a VPN. I use one again myself routinely. These are all things that you should be considering. If you're running a business, you should be considering one of the existing standards. The UK has a standard approved by the UK government and by GCHQ, in fact, the National Cybersecurity Centre, called Cyber Essentials. At the lowest level, it is relatively cheap. It involves you filling in a questionnaire. So it's really important that that you consider the Cyber Essentials standard, and I would advise any business to sign up to Cyber Essentials. The other half of the GDPR people tend to forget about is data integrity and preservation. So people think that the GDPR is all about erasing data, and the obvious resolution to all GDPR problems is just to delete everything as quickly as possible. But actually, the GDPR is not just about data security and getting rid of data. It's also about data integrity and data preservation. So that means ensuring the data has integrity in terms of it not being altered by people who shouldn't be altering it. But also it means preserving data so that important information is not lost. So, for example, if you hold a tenant's rent payment records, which are, of course, useful to them potentially for references and things like that, and you lose that data because your laptop self-terminates or is lost and you don't have a backup, then you have violated the GDPR because you have not preserved important data that has value to data subjects. So it's not just about getting rid of stuff. There's also an element in which you need to make sure you have a proper backup policy and you're making sure you're preserving, protecting data. So passwords, for example, aren't just there to, and encryption are not just there to make sure that the data doesn't leak out. It's also to make sure that someone doesn't come in and start mucking about with the data and changing it unexpectedly. So data integrity and data preservation are as much about this as data security. Not thinking about the roles. GDPR it works on the basis of data controllers and data processors. Ultimately, a data controller is the person who decides how data is to be processed, and processors just process according to a controller's instructions. So as between landlords and agents, the controller-processor status is somewhat unclear. But the reality is that when a person becomes a tenant, the landlord is likely to be a data controller of that data because they can take that tenant away to a different agent along with the data and carry on with it. Now, the fact is agents are probably also data controllers, and landlords and agents are probably in a joint controller situation whereby the landlord is controlling a lot of the data, but so is the agent, because, of course, agents deal with tenants before they become tenants of landlords, i.e. when they're prospects and looking at property, but also they probably want to deal with them again afterwards. So if the landlord no longer wants to rent to that tenant for whatever reason, the agent may want to try and put them into another property. So they're probably joint controllers. But the important point to bear in mind here, especially if you're a landlord, is that you cannot divest yourself of your responsibility for handling the GDPR to your agent. You are a data controller because you control the tenant's data. You can choose to take it to a different agent. Even if the agent's handling it for you and you don't see much of it, you could fire the agent and walk off with the data to somebody else. So in practice, you are a data controller, and the responsibility for compliance with the GDPR falls entirely on data controllers and not on data processors. So landlords have a responsibility as a controller for compliance with the GDPR. The sixth thing to think about, giving information. GDPR is crucial. One of its key elements is the provision of information to data subjects, and particularly about what you're doing with their data. And this is what's called the privacy notice. Now, I know if you're a member of Tessa's service, you can get one of her privacy notices, which is a good template to work with. But obviously, you need to think about it in terms of what you are doing. So every single person whose data you process or who you're instructing someone else to process should be provided with a privacy notice setting out what is being done with their personal data, why that is being done, who it's being done by, and for how long you intend to do it and when you're going to get rid of it. And this should be given at the time the data is collected or as soon as possible thereafter. Now, of course, agents can do this on behalf of landlords frequently, but it's an absolutely core element of the GDPR. And if you don't have an agent, or your agent is a tenant find only, it's your responsibility as a landlord to deal with it, and you really need to make sure you're doing it. If you don't do it, you can be reported to the ICO. And the reality at the current time is that complaints to the ICO are going through the roof. People are much more aware of what's being done with their data. And also, frankly, during lockdown, quite a lot of people haven't got much else to do. And so ICO complaints are just up, just generally because people like complaining about stuff sometimes, and they enjoy it, and they're a bit bored. Consent. I can't emphasize enough how unimportant consent actually is in the GDPR. The GDPR requires you to have a proper processing basis in order to process data. But it's a big change from previous data protection regimes, because previously all you needed to do was get people to consent to processing your data. It was a very American style approach to data protection. You basically said, do you consent to processing the data? Thanks. And the way this was often done is agents would stick a clause in their terms of business saying the landlord consents to them processing the personal data. And in tenancy agreements, there'll be a clause in there saying, oh, the tenant consents to the landlord and the agent processing their personal data for whatever basis we think. That is wrong. And under the GDPR, it is not an acceptable mechanism for processing data, and it is high risk, because under the GDPR, any consent that is given can be withdrawn at any time, and you can't prevent that happening. And if you're therefore relying on consent, for example, to process tenants' data, and they then don't pay the rent, and they say to you, I'm withdrawing any consent to process my data, it makes it incredibly difficult for you to, for example, instruct a solicitor to evict them. Now, obviously, there are other processing bases you can rely on, but you will then have to rethink the withdrawn consent, tell the tenant you're relying on a totally different processing basis, and there'll be a delay while you sort it out. So you need to think about the correct processing basis, and your privacy notice, which I already mentioned under information, should set out what processing bases you are relying on. So there are lots of other appropriate processing bases that are more relevant than consent for landlords and for agents as well. So the obvious one is I'm processing on the basis of a contract between us. Obviously, landlords and tenants have a contract. It is necessary to process data to fill the terms of the contract. You're going to find it very difficult to let a property to somebody and organize repairs, for example, if you don't know who they are and you can't process their data. So there's a legitimate processing basis there. Legitimate interest is an acceptable processing basis. If, for example, the tenant doesn't pay the rent, then it is within your legitimate interests to instruct a solicitor and to pass the tenant's data to the solicitor to pursue your legitimate interest in suing them for not paying the rent and evicting them from the property. It is within your legitimate interest to inform the council tax authorities who should be liable for the council tax on the property. And then the other processing basis that's relevant is legal obligation. So you are obligated by law to do something. That is always a legitimate processing basis under the GDPR. Obvious examples there are right to rent checks. You are obligated by law to carry out a right to rent check and to store the data until a year after the tenancy is ended. And so the legitimate processing basis there is legal obligation. So there are lots of other processing bases that apply to almost everything landlords and tenants and agents are doing. And consent is not the one you should be using. Consent is the one that you should be using if no other processing basis can reasonably apply. But you shouldn't be putting it into strict agreements, because it implies, therefore, that consent is necessary for the performance of the agreement, which it isn't. And it implies that consent is non-optional, which I'm afraid it is. And also, consent must always be on an opt-out basis. So consent shouldn't be in an agreement. It should be separated. It should be opt-out unless I choose to opt in. And I should bear in mind it's always withdrawable. And in practice, as between landlords and tenants, and as between agents and landlords, consent is almost never an appropriate. In fact, I would go even further, say consent is just never an appropriate processing basis. It may be appropriate for agents for some marketing purposes, but only some. Some marketing purposes can be carried out under legitimate interests as well. But consent is a really, really limited processing basis and is largely linked now to marketing activity. It is not an appropriate processing basis for anything really that a private landlord and tenant or an agent and landlord and tenant are taking part in. So don't abuse consent. don't deal with access properly. So subject access requests are an important part of the data protection regime. They were important under the old regime. They're equally important under the new GDPR. Again, they've gone through the roof recently. The Irish data protection regulator has suggested they've had a 110% increase in subject access requests in the last year. The ICO is indicating similar numbers. So they're going up and up and up and up and up. So the GDPR, just like any other data protection regime, allows people to access their data, or more correctly, to ask what you're doing with their data by way of a subject access request. And that can be made by any method. I don't have to fill in a form or do it in writing. I can do it on the phone, and I can do it to any person employed in your business. So if you're an individual landlord, obviously there's only one person I can talk to. But if you're an agent, for example, I'm perfectly entitled to phone any person in your office and make a subject access request. And it's up to you to make sure your staff are properly trained to recognize a subject access request and know how to deal with it. If a subject access request is made, then you have to respond within a month. And that's a strict month. We're not joking about that. That's not a month plus a few days. It is a month tops. It can be extended to 3 months in exceptional cases, and you have to give reasons, and they need to be good reasons as well. You can't just say, because I'm that's a hassle, I'm busy. It has to be a month in most cases. But it's important to realize that this is not a right to see documents. A subject access request is a right to see my personal data and be aware about what you're doing with my personal data. It's not necessarily a right to see every single document that my name is mentioned in. And so particularly in relation to access requests, they're often used where people are snarked off with each other, and they're used for sort of fishing expeditions to try and find some other basis to sue somebody for. That is not the purpose of a subject access request. So if I make a subject access request demanding to see all emails with that contain my personal information, the reality is of those emails, some of them will be nothing more than emails that mention my name. Some will be a mixture of an email that is about me, but also about other people and about other stuff. Some will be wholly about me and will be almost impossible to remove my personal information or separate it from the email. So that third category, emails that are wholly about me, they are disclosable in full. Emails that contain a mixture of information that's personal information and other stuff are not disclosable in full. You can redact them, for example. And emails in the first category that merely mention my name, you don't have to disclose those at all. You're perfectly entitled to turn around and say to me, we found 500 emails in which your name was mentioned. There is no other personal information about you in that email, for example. So people misunderstand subject access requests, and people are using them as fishing expeditions to demand documents. You don't have to give all the documents, is the short answer. It is also possible to refuse a request that is manifestly excessive, but with a bit of caution there. You should bear in mind that just because a request is going to involve you in a lot of work, that doesn't make it manifestly excessive. And if you haven't organized your data properly, so it's particularly hard for you to fill it, that's your own problem. That is not the responsibility of the data subject to deal with. So manifestly excessive is quite limited. And you need to bear in mind that if you're saying something's manifestly excessive, one, if you refuse a request on that basis, you have to tell people about their right to complain to the ICO. And two, they're clearly going to complain to the ICO about it. Deletion, you need to bear in mind that data cannot and should not be kept forever. You need to have a policy, ideally, or a plan to get rid of data. You need to really make a distinction between data you're required to keep by law. So I've talked about right to rent data, which needs to be kept for a year after the end of the tenancy. The data it should be deleted after that period. You need to keep data after the end of the requirement by under the right to rent, for example. So stuff you have to keep by law. There's data you need to keep to protect your rights. Well, that data you can keep for as long as you need the right protecting. So, for example, it's legitimate to keep a tenancy agreement and other documents relating to a tenancy for 6 years after the end of the fixed term, because that's kind of the limitation period on suing people. And then there's data you don't need to keep at all. If a tenant's left a property and there's no problems at all, and everything was fine, and the property was handed back in good condition, can you really justify keeping their bank details, for example, and the bank account statements that they provided to you prior to the start of the tenancy for referencing purposes? Probably not. So deletion needs to be nuanced. And obviously, if you are deleting data, I should point out here very clearly, you need to delete it properly and not do what keeps happening at the moment, which is where people leave it in bin bags outside their house or outside their offices. And then not registering. I saw someone ask the question about this. The UK requires data controllers to register with the ICO and pay the relevant annual fee. Almost all data controllers need to register with the ICO. Processors don't need to register, and people only dealing with personal or family data, i.e. your own stuff, your own family, don't need to register, but that won't include landlords. And there is no circumstance where a landlord won't need to register unless they are doing everything on paper and don't use any electronic data storage or transmission at all, i.e. you don't use a computer to handle your property business, you don't use a mobile phone, you don't use email, you do everything by handwritten tenancy agreements and handwritten letters, which those people do exist, but they're pretty rare. Those people would not need to register. Anyone else who's acting as a landlord is operating as a business and will need to register for the purposes of the ICO and pay the fee. So there's my top 10. I'm happy to take a few questions, and I see there are a few which I could answer. Tessa, are you still there somewhere? Right, so I'll try and answer a couple of these questions. Hopefully Tessa will pop up at some point. So John has asked, if an email is sent to somebody, then there is a relationship between that person and yourself that identifies your relationship by name and mail address, both of which are personal data. Why is this not covered? I didn't say it wasn't covered. It is covered. What I said was that a subject access request is not covered if there's no personal data involved. And then John's also asked if a GDPR policy statement. If a GDPR policy statement forms part of the tenancy agreement. No, this is often a mistake. A tenancy agreement and a policy statement are different things. A tenancy agreement is a contractual relationship. A GDPR privacy policy is an information statement only. So if you're only if you're a GDPR privacy policy is not a contract, it is a piece of paper that says this is how I'm going to process your personal data. So no, it's not part of the tenancy agreement, and there's a key point there as well, which means that you can change it. You can change your privacy policy at any point, and all you really need to do is tell people about it. And so it doesn't matter that you make changes to your privacy policy from time to time. You can change it whenever you like, and it doesn't. It's up to you. And indeed, I encourage people to do this. One of the problems that people have is that they tend to think they can't change the privacy policy, which means that either they're not telling tenants about how they're processing the data, or alternatively, they don't. They're not changing the way they're processing data to keep up with times because they feel they're stuck with their policy.
David, can you hear me now?
You're back.
Yes, well, I was there all along, actually, but for some reason, nobody could hear me. I don't quite know what happened. You should have been able to hear me. Have we answered all the questions?
I've answered some, but I'm happy for you to pick some stuff up. So Mark has asked, saying a case management system you used to use that says file deletion is not possible, which is bizarre. Yes, there are lots of people who say they can't delete files. That is not compliant with the GDPR, but it is a common problem. I should be very clear about deletion. A deletion policy is obviously in tension with a backup policy. No one is suggesting that if someone says to you, I want to be deleted, you have to erase them from all computer systems and everything from the world that you know about or from your brain. the right to request deletion means you have to remove them from active processing. And if your backup policy works properly, that should mean as your backups work through, then you should you should be sort of clearing out, as it were, through your backups, and your policy should work on that basis.
Yeah.
Someone just pull up another one I just want to quickly pick up. Sorry, Winifred's asked if all your info is backed on the cloud by a successor of Mozy Pro. I think I've told tenants the servers outside the EU and UK, but I can't find out. You have to do more than just tell a tenant if their data is outside the EU. You have to consider where it is. You have to conduct a risk assessment if the area doesn't have an approval, and if it's the US, it doesn't. And you have to consider whether there's sufficient protection in place. If you can't find out, then I would suggest to you that probably means you should be finding an alternative backup system, because that backup is not GDPR compatible by default.
Yeah, I mean, you have to sort of check up all your suppliers and companies and check that they are GDPR compliant. And there's the ICO has got a really helpful website, and I think they've got sort of checklists, haven't they, David, that you can work through to sort of assess that you are compliant with the regulations.
And they're usually quite good, but they are confusing. I mean, one or two people have just said to me there's a couple of people have popped up saying, do I really need to register with the ICO because I just have one property, or the ICO's website suggests I don't need to register? Yes, you do. If the ICO's website has told you don't need to register, you've probably not understood, or to be fair, their checker as to whether or not you need to register is not terribly well worded. But I can assure you, if you're a landlord, however many properties you own, you are a data controller and you must register with the ICO.
It's not a huge amount of money. I mean, it's 40 quid a year, 35 if you pay by direct debit. It's
there's a £5 off for a direct debit, so you can get a registration and a large glass of wine. if you can find a pub that's open.
Okay, right. Well, we're past the hour now, so I think we better close down. So it remains for me to say thank you very much indeed, David, for coming on and presenting this webinar, and indeed all the others that you've done in this series. We may do another series at some stage in the future, but this is the last one for now, apart from the one we've got with David Cox next week. So thank you very much, David. This is being recorded, and you will be able to access it in due course on the Landlord Law YouTube channel. Okay, I shall close down now. Bye-bye, everybody.